So yesterday, the Illinois city of Naperville and the state of Illinois, they filed responses to the U.S. Supreme Court in the case that law weapons owner Robert Beavis brought, challenging the city of Naperville's gun and magazine ban, but also the state's ban as well. We'll actually talk with Robert Beavis coming up after 7 o'clock here. Actually, I believe it's going to be after 8:10 this morning. 8:10 this morning, we'll talk with Robert Beavis about where he's at with his challenge and what exactly is going to be happening with the ongoing problems he has with not being able to sell certain types of weapons. So he actually filed to the U.S. Supreme Court after a Northern District judge determined that the city's ban is constitutional and the state's ban's constitutional. Beavis and others in the Naperville case took that to the Seventh Circuit Court of Appeals. And in the Seventh Circuit Court of Appeals, they asked for a preliminary injunction to be put in place. That preliminary injunction was essentially shot down by the Seventh Circuit Court of Appeals. So Beavis and his attorneys took it all the way to the U.S. Supreme Court and asked Supreme Court Justice Amy Coney Barrett to issue a preliminary injunction. And if you follow along with all of this, you can see the docket for the Supreme Court's request for a preliminary injunction, and it's got all of the filings that are listed and the responses that are listed as well. And part of the response coming from the state of Illinois, and you can actually click through and see that response. And just going over some of the top headlines here, you've got the questions that were raised and the response that the state made, saying that applicants have shown that the court's likely to grant cert or that an injunction would be in the aid of the court's jurisdiction. They argue that applicants have not shown that they're indisputably entitled to relief. They also go on to show that it's not indisputably clear that the act regulates conduct protected by the Second Amendment. The state also argues that it's not indisputably clear if the act is consistent with national and historical regulations of firearms. And again, going on with other arguments the state makes, no critical or exigent circumstance exists that would warrant an injunction pending appeal. So you can go through, that's just the overhead of all of the various arguments they're making, and the 44 pages, you can delve even deeper into it. And some already pointing out that they're saying that semi-automatic weapons are more dangerous than rapid-fire weapons, and other arguments being pointed out on social media as just what some say are nonsensical. But it wasn't just Illinois that responded. You also have the city of Naperville responding as well. And if you click through and see their document, it's very similar to the arguments that the state made. And an interesting note, you've got Perkins Coie being one of the attorney groups for Naperville. That's a very closely aligned Democratic law firm. But the arguments they make in an overhead, they say applicants have not shown this court's likely to grant cert on their requests for interim relief. They go on to say that applicants have not satisfied the high bar for an injunction pending appeal. They say that it's indisputably clear that applicants will prevail in court, and they say that this court has not addressed the validity of Naperville's sales ordinance. Applicants will not indisputably prevail at either step of the Bruin analysis. That's something that's going to get a lot of people riled up. And they also argue that applicants have failed to establish that any irreparable harm would result from denying their application. Now, when we talked with the National Gun Rights Association, they laid out that, and we'll hear from Robert Beavis after 8:10 this morning, about the harm that he's experiencing by not being able to operate his business. And this is obviously a big issue that Beavis once addressed. Meanwhile, the city of Naperville argues that Naperville's sales ordinance reflects the public policy choice of its citizens through their elected representatives, an overhead argument that they ultimately make. And if you go all the way down to the conclusions, that is a way to kind of help summarize what they are saying is the reason that they want the Supreme Court to step out of it here in this moment. They say since Bruin, lower courts have engaged in the difficult but important work of adjudicating disputes concerning the scope of states and municipalities' rights to regulate aspects of the sale and ownership of firearms. Applicants seek to vitiate not one but two levels of review, effectively to divest both to the district courts and the circuit court of their authority to resolve the merits of the underlying claims. They fall far short of the high bar that this court has understandably set for emergency relief. The application should be denied. So that's the response that Naperville provided to the U.S. Supreme Court, that Amy Coney Barrett demanded that Naperville and Illinois respond. And we'll see, obviously, where this goes from here. But this is just one element of the litigation against Illinois' gun and magazine ban. And that gun and magazine ban being challenged not just in federal courts, but also in state court. And if you check out my most recent article at thecentersquare.com, I broke down some of the other cases there are. In state-level courts, the Illinois Supreme Court set to hear oral arguments May 16th in the challenge that State Representative Dan Calkins out of Decatur brought out of Macon County. Arguments there include that it violates equal protections by carving out police, retired police, and others in the law enforcement and security sectors. Separately, cases brought by attorney Thomas DeVore had a status hearing Friday in Effingham County. DeVore seeking documents from legislative leaders and third-party associations about the passage of the Protect Illinois Communities Act. A county judge last week took motions to dismiss and quash subpoenas under advisement, meaning that the judge heard arguments on Friday, and the judge is going to ultimately rule on whether or not to quash these subpoenas. The Calkins case and DeVore case have thousands of named plaintiffs with temporary restraining orders against the state from enforcing the law, and it's unclear how Illinois State Police's statement Friday to the Center Square impacts those plaintiffs with the TRO in place. Now, the agency didn't immediately respond to my request for comment. They did ultimately get back to me and just pointed to their frequently asked questions portion of their website about the Protect Illinois Communities Act, and in particular, the portion about the Macon County case. And that says that the current Macon County judgment and any TROs entered in other actions are only applicable to specific plaintiffs and defendants in those actions. They say more information will be forthcoming as additional rulings transpire through the state and federal courts and when the Illinois Supreme Court rules on the matter. So that's kind of where we're at in the challenges against Illinois' gun and magazine ban. With the federal courts a stay in place against an injunction from the Southern District. The Seventh Circuit Court of Appeals put that stay on the injunction, and now you've got the Naperville case in federal courts up to the U.S. Supreme Court, where they could, ultimately in a couple of weeks after holding a conference, because Coney Barrett, she could either, rule on a emergency injunction by herself, or she could sit down with other justices during conferences, which they have several conferences each Thursday through June. So that's still coming up. But you've got the possibility that they could conference and in a matter of weeks make a decision on whether there should be an emergency injunction. Again, that's in federal court. In state court, you've got a lot of movement as well anticipated with the Illinois Supreme Court taking up the question of equal protections that attorney Thomas DeVore has brought in separate cases, but the Supreme Court's going to be hearing State Representative Dan Calkins' case. So a lot of moving pieces. We'll do what we can to cover it all for you each and every morning, as we have here with Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. And you can always call in live and local. I'd love to hear from you at 217-629-7970. That's the phone number here, where you can have your voice heard and the latest of what's going on with Illinois' gun and magazine ban. Big shout out to everybody tuning in on social media. We've got a huge view count right now, and obviously this is an important issue that a lot of people are interested in, and they want to get more of the details, and we'll talk a lot more about it, including a conversation with law weapons owner Robert Beavis after 8:10 this morning. After 7:10 this morning, we're going to jump into the constitutional sheriffs. And if you recall, when this first passed, sheriffs across the state said they're not going to enforce this. Well, Sean Casten, a U.S. congressman out of the Chicago suburbs, he held a forum with people on the weekend and talked about the dangers of these constitutional sheriffs. So we'll talk about that as well. All of that's on the way here with Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk.